Hi everyone, I'm Victor Martins, lawyer with Martins Law, located in Vaughan, Ontario, where we assist clients with life's most important decisions in the areas of real estate and wills and estates law. I'd like to thank everyone for tuning in to our first video. I hope that this will be the first of many videos to come where we cover important topics in both of our practice areas. For this first video, we wanted to dive into a topic that lies right at the crossroads of both real estate and wills and estates law. And that topic is the distinction between co-owning real estate as tenants in common versus as joint tenants. This is a distinction that's often overlooked, and rash decisions are made in regards to not only by clients but also by lawyers. To put this into context, clients should be prompted to decide whether they wish to take title as joint tenants or as tenants in common prior to closing by their real estate lawyer. And ideally, their lawyer should also be advising them on the practical differences between the two so that their clients are making an informed decision. Another thing to note prior to diving into the practical differences between the two are that these forms of ownership only apply to co-ownership. In other words, they only apply when two or more people are taking title together. So diving right into things, let's start off with what a tenancy in common is all about. And we'll start there because this tends to be the form of co-ownership that is easiest to understand and is most intuitive for most people. So with a tenancy in common, two or more co-owners take ownership to property with distinct percentages of ownership. The most common split that we see is a equal 50-50 percentage split. However, as long as the total percentage of ownership adds up to 100%, the ownership percentages can be unequal. So you might have two co-owners that are 50-50 owners, or you might have a situation where there's a 60-40, 70-30 split. And typically, we see those unequal percentages of ownership when there's been an unequal contribution to the purchase price. So in terms of tenancy in common, although two tenants in common might own, for simplicity's sake, let's say 50% of the property each, they both own 50% of the whole without being able to point to their specific 50%. In other words, there's no line in the sand, there's no property boundary or division, there's no west wing of the house versus east wing of the house that either tenant in common could point to say, that's my physical share. Again, they own their percentage of ownership amongst the whole of the property without being able to physically carve out or divide their percentage from the other tenants in common. The key in terms of estate planning and the reason why it's such an important decision to make in terms of how co-owners legally decide to take title is because although you make that decision prior to purchasing your home or other property, that decision has a bearing on what happens to your ownership in the property when you pass away. So therein lies the estate planning component to making that decision. With a tenancy in common, when a tenant in common passes away, their percentage of ownership passes to their beneficiaries in accordance with their will, or if they have no will, then in accordance with the relevant intestacy laws. So let's say you have an owner A and an owner B. They both own 50% of a property. When owner A passes away, assuming that they pass away first, owner B holds on to their 50% ownership that they originally had, but owner A's 50% goes to who they name in their will as beneficiary. So if that happens to be owner B, great, then owner B would become the 100% owner. But if that happens to be someone other than owner B, then again, owner B would keep their 50% interest. And as to owner A's 50% interest, that becomes inherited by the beneficiaries named in owner A's will. The second important kind of co-ownership is called a joint tenancy. With a joint tenancy, two or more co-owners don't take a distinct and separate percentage of ownership in a property, but instead they choose to own 100% of the property together. Um, so if you were to ask a joint tenant, technically and legally speaking, how much do they own of a property that they hold as a joint tenant, they should say 100% of the property, with the caveat being that their fellow joint tenants also own 100% together with them. So the key for a joint tenancy, and why this is an important option to explore with your fellow co-owners prior to completing your purchase, is because it has major estate planning implications. When one joint tenant passes away, their interest in the property is automatically absorbed by and inherited by their surviving joint tenants. So if you have two joint tenants that take a property, again, as joint tenants, um, and when one passes before the other, then their surviving joint tenant becomes the sole owner of the property. The first joint tenant to pass his share automatically becomes absorbed by them. And the interesting thing and the important thing about a joint tenancy designation when taking title is that it overrides the terms of your will. It itself is like a mini will in as so far as that specific piece of property goes. If a joint tenant has a will that names somebody else other than their fellow joint tenant as the beneficiary of all of their property, then when they pass, the joint tenancy designation on title overrides their will for that property, that piece of real property, and makes it so that their surviving joint tenant inherits their interest and becomes the sole owner, notwithstanding what their will says. One of the major benefits to a joint tenancy is that because it passes automatically to the surviving joint tenant by what's called that law a right of survivorship, in that way it passes outside of a person's estate, and the legal and more importantly the financial benefit to that is that the transfer of ownership doesn't attract estate administration taxes, aka probate fees. So you may still, in order to administer the first joint tenant to pass his estate, in order to administer it, you may still need to go through the probate process for other reasons. But insofar as the property goes, that'll pass based on the joint tenancy designation outside of their estate, thereby avoiding estate administration taxes, aka probate fees on it, which can be significant. Um, uh, for every $1 million of property that passes through someone's estate, the probate fees on that are approximately $15,000. So if you have a property that's worth $2 million that passes by joint tenancy outside of a person's estate, the savings there are $30,000. So now that we've explored the practical differences and the estate planning importance, to what a joint tenancy is and what a tenancy in common is. Let's briefly look at who chooses to go with one over the other. So for tenants in common, um, the people that typically choose to go with that form of co-ownership are investors or business partners who say, in the event that either of us predeceased the other, while our business is still ongoing, they'd like to keep their ownership interests separate, and they'd like to control where their percentage of ownership goes, as opposed to it automatically flowing to their surviving business partners. The other situation where it's common for co-owners to take title as tenants in common is for new or recently married couples um, who, whereby this will be the first time that they're living together in a home. They're kind of testing those waters. And as a result, they want the protection of knowing that they'll have a distinct percentage of ownership, and that if either of them dies before the other during the early stages of their relationship, then they'll have control over where their percentage of ownership goes. With joint tenancies, on the other hand, you tend to see those taken up by married or common law spouses who are just quite fine and quite comfortable in structuring their ownership of the home such that if they pass away prior to their spouse or common law partner, that other person automatically inherits. And they tend to be content with that because that lines up with their wishes and their values in the first place. So just a few notes to cover before we close off. I've been speaking in terms of both options a lot in my examples in terms of there being two owners, but there can be a tenancy in common or a joint tenancy formed between more than two co-owners. So with a joint tenancy, let's say you have three co-owners, and one passes away before the other two. The joint tenancy lives on, and that one joint tenant's interest passes to the surviving two joint tenants um, automatically upon that first person's death. With a tenancy in common, you can again have more than two owners. So let's say you have three, four owners, and with more than two owners, it can still be the case that they own the property in equal percentages or unequal percentages. So let's take the example of four co-owners. Those four co-owners may own the property equally in four 25% percentages of ownership, or there might be a different split. Let's say it's 20, 20, 20, and 40. Um, so that's important to note for the overall context of the information I shared in this video. And the other thing to note is that the designation in terms of whether you co-own with one option or the other, you make that designation prior to the closing of your purchase, but it can be changed in the future. So for that, you would have to seek out a real estate lawyer, and what they'd be preparing for you is a transfer um, from you back to you, back to the co-owners, but with that different designation. So again, it's important to note that you make the designation before you purchase, but it can be changed as a later date. The third important point I just want to cover off is that um, once there is a death as between tenants in common or as between joint tenants, um, title doesn't automatically get cleaned up to reflect the new circumstances of ownership. You have to go to a real estate lawyer who does what's called estate conveyancing in order to make the appropriate registrations on title to have the new circumstances, the true circumstances following the first person to pass following that death, in order for it to be properly reflected on title as to what the ownership structure looks like. So that's the gist of the differences between co-owning as joint tenants or as tenants in common. Um, the first time that many clients hear these words, they kind of might write it off as legalese and something that's not that important. But as we discussed, it does have a major bearing on your form of co-ownership and, more importantly, on your overall estate plan. Because for many people, the real estate that they own is their largest asset. Um, and You have the option prior to purchasing, or at any time afterwards, to determine how that will fall into your estate plan just based on the designation you put on your co-ownership. So I'm hoping that this video helped some folks to understand the differences between these two options, and I hope that it comes into play on your next purchase, and that you're thinking about that decision more critically against the backdrop of your overall estate plan, as opposed to making a rash, uninformed decision. Um, Again, I'm Victor Martins from Martins Law, and if you have any questions regarding uh, the information I shared in this video, please feel free to reach out. Thank you all and have a great day.